The last two arguments this morning are numbers 46 and 47. Number 46 is Jacob Doyle Corman III et al. Versus the Acting Secretary of the Department of Health. And the second case, number 47, is J.W. et al. Versus the Acting Secretary of Health. Before this court are two petitions that have challenged an order issued by Alison Beam, Pennsylvania's Acting Secretary of Health. This order requires all staff, students, and visitors to wear masks while in any public or private school in Pennsylvania in order to mitigate the spread of COVID-19. The two petitions seek a declaratory judgment that the Secretary's order of August 31st, 2021 is unlawful. In case number 46, petitioners who are parents of minor children argue that the Secretary's order is unlawful because it constitutes a regulation required to be promulgated in accordance with the Commonwealth Documents Law and the Regulatory Review Act, and it was not so promulgated. They also argue that requiring a mask is a disease control measure not authorized by Pennsylvania's statute, the Disease Prevention and Control Act of 1955. In the alternative, petitioners argue that if the Disease Control Law of 1955 granted the Secretary unlimited discretion to adopt new disease control measures, then it is unconstitutional in violation of the non-delegation doctrine. In case number 47, the petitioners are also parents of minor children. They argue that the Secretary's order has burdened their exercise of religion, which is a right protected by the Pennsylvania Constitution, the Public School Code of 1949, and the Religious Freedom Protection Act. Petitioners contend that the Pennsylvania Constitution guarantees their minor children an inherent right to breathe clean air without restriction to the free exercise of their religious belief and to a public school education. They argue that the Disease Control Law of 1955 has granted local and county health departments primary responsibility for the prevention and control of disease, except where the Department of Health has determined the program is so inadequate that it constitutes a menace to the health of the people. No such determination has been made here by the Department of Health. For her part, the Secretary argues that she was authorized to issue her order by the Disease Control Law of 1955, the Administrative Code of 1929, and the Department's regulations. The General Assembly has charged the Department of Health with the responsibility to prevent and control disease and has provided adequate standards to guide the Department's exercise of its discretion in that regard. The Secretary argues that local health departments are subject to the state supervision and they have no authority to relax the state's measures. The Secretary rejects the petitioner's free exercise of religious claim because the order is content neutral and rationally related to a legitimate government interest. In each case, the petitioners and the respondent have filed an application for summary relief. They contend that the legal questions presented in these two petitions for review are purely legal and do not require an evidentiary hearing. According, each party requests that judgment be entered in its favor. And because we are hearing these cases seriately, we will, and this is an en banc argument with more argument time, we will hear from the petitioners for number 46 first, then the petitioners for number 47, then we will hear from the Secretary of Health. The petitioners will each get 15 minutes to argue. The secretary will be given 20 minutes to argue, and then all three parties will have an opportunity to present 5 minutes of rebuttal time. I suggest that the petitioners address not just their argument in favor of their legal position, but to some extent use your 15 minutes to address the Commonwealth response. And with that, we'll call petitioners in number 46.
Thank you, Judge Leavitt. If it pleases the court, Attorney Tom Breath for the petitioners in this matter. If I understand, Your Honor, we've got 5 minutes reserved for rebuttal.
Correct.
Thank you, Your Honor. Let me start by just briefly discussing the issue that's before the court. We have an agency, the Department of Health, that promulgated a regulation. That agency now is attempting to interpret that regulation in a manner that would give the agency broad discretion to formulate, outside of the regulatory review process, subsequent regulations, implementation of other control measures. The starting point in the court's analysis, we would respectfully assert, is with the underlying statutory authority. And this is not, let me reiterate, that this is not a case about the appropriateness of wearing masks or the seriousness of COVID. This is purely a legal issue on whether the Secretary of Health has the authority to issue the order that she put down on August 31st of this year. The underlying statutory authority comes from the Disease Prevention and Control Act of 1955. The Secretary has specifically referenced Section 521.5 control measures in her order as authority for that. That is the starting point. Nobody is disputing the fact that the General Assembly has the authority through the approval of statutes to make general policy determinations and to delegate authority to the agencies of the Commonwealth. What is at issue here is the constraints that were placed upon that agency by the General Assembly and whether those constraints and controls or guidance for that administrative function are being followed or being abused. I'll cite the court to the specific language in Section 521.5 control measures. And I'm going to leave out local health departments for now, or health boards. Upon the receipt of a report of a disease which is subject to isolation, quarantine, and other control measure, the department shall carry out the appropriate control measure in such manner and such place as provided for by rule or regulation. There are some significant points in this language. First, a report is received. A determination has to be made whether that report involves a disease that is subject to isolation, quarantine, or any other control measure. How can that determination be made unless the control measure exists at the time of the report? Further, that section goes on, that the department then shall carry out the appropriate control measures in such manner, in such place, as provided by rule or regulation. Once again, that rule or regulation must be in place at the time that the report is received by the department. If it's not there in rule or regulation, it is not, for lack of a better phrase, a tool that is available to the Secretary of Health. The Secretary of Health has the authority to isolate, quarantine, and other health measures that are in existence as of the time of the report. The Secretary goes on to refer, and I'll deal with the administrative code in the sections referenced there, but the Secretary next goes on to reference Regulation 2760. And once again, the language of 2760 does not give the Secretary the authority that she has asserted in issuing this order. I'll back up 1 second. The underlying statutory authority, 521.5, clear and unambiguous. There's no dispute there. There's no allegation that 521.5 is somehow ambiguous as to what it is saying.
If I could just go back to Section 5 of the statute. Your position is that the disease control measure has to exist by rule or regulation before there's a report of a disease?
At the time that the report comes in of a contagious or infectious disease or infection, the department, pursuant to 521.5, has the ability to make isolation determinations, quarantine determinations, and any other control measure in such manner and in such place as is provided by rule or regulation.
So your position is that if the rule and regulation does not already exist, then one needs to be promulgated before action can be taken?
Absolutely, Your Honor.
How is that different from what this court said in the cracked egg case?
In the cracked egg case, that was a little bit different, Your Honor. I think the cracked egg case is not relevant. We hear it in a lot of the arguments that we have here.
Well, in that case, we were talking about measures that were taken to protect against the COVID-19 virus. But was that case different? Because in that case, there was an existing emergency proclamation?
There absolutely was, Your Honor. At that time, as we all know, the citizens in the Commonwealth of Pennsylvania have passed 2 constitutional amendments that have stripped that away. The declaration is gone. We no longer have, in the Commonwealth of Pennsylvania, a COVID emergency.
Would that have made this case different had there been a second declaration or another declaration based on perhaps a new variant? Would that have made this different in that then the order might have been appropriate without a regulation in place?
Well, it would have changed the focus to make the focus twofold. What authority does the governor of the Commonwealth of Pennsylvania possess under the Emergency Management Act, and what authority does the Secretary of Health have under the Disease Prevention and Control Act? We're down to the Disease Control and Prevention Act. I don't know if it would have changed. I think the scrutiny at that time, I think would have been the same. I think we're here today because we now have a subsequent order that is, we've morphed out of the business shutdown orders, the stay-at-home orders, and the phased progression out of the pandemic, which was in a completely different environment 12 months ago. We're 18 months, 20 months into the pandemic. We're now left in the Commonwealth of Pennsylvania with the sole authority resting within the Secretary of Health. The Secretary of Health has a clear policy statement. We're not arguing that the Secretary of Health has been charged with the general provisions of the health, safety, and welfare of the citizens of the Commonwealth.
Let's talk about that in regards to 521.5 before you leave that, and 521.3, which I believe the two have to be read in pari materia. 521.3 makes clear that local boards and departments of health, in subparagraph A, shall be primarily responsible for the prevention and control of these communicable diseases, including in public and private schools, in accordance with the regulations of the board and subject to the supervision and guidance of the department. The department there being the little d referred to in the first line, local boards and departments of health. So in light of that, and under 521.3C, the only way that the secretary can intervene into the local autonomy of the boards of health and the departments is if there is a finding that the program being carried out by any local board or department is so inadequate that it's a menace, and it goes on to say then what the secretary may do, which is the following: appoint agents of the department to supervise or to carry out the disease control program of the particular local board or department until he determines the menace is no longer existing. That didn't happen here, did it?
Correct, it did not happen.
Okay, so in 521.5, you skipped over the language upon the receipt by a local board or department of health and just jumped to the department. How can you do that? Don't we also have to look at whether, in this case, 521.5 still gives local autonomy to the local boards and departments of health? And that's another reason why 521.5 doesn't even apply here, because it was upon the receipt by a local board or department of health or by the department, as the case may be, of a report of a disease. Do we now look at 521.5 and ignore the local autonomy of the school boards?
No.
So isn't that another issue as to whether there was even authority to act under 521.5?
Well, I think it is. I think it is with respect to the municipalities or the counties that have local boards or departments, which not all do. Since this is coming out from the Secretary of Health, I've focused on the department, but Your Honor is absolutely right now. In response to Judge Leavitt's request that we address the Commonwealth.
Yes.
The assertion is that the local boards, that somehow the Department of Health's order is the floor, if you would, and local boards and local departments have the authority to put in place even more stringent. Once again, we're ignoring the fact, in your reference to 521.3, Your Honor, those local boards and departments are constrained in the same manner as the Secretary of Health by the rules and regulations that have been promulgated through the advisory board the whole way up through their boards. They cannot just create their own rules and regulations.
Well, counsel, I don't understand how you can even get into this argument without also taking into account the administrative code, which is very broad in terms of the health department's ability to prevent and suppress disease. What if there was an outbreak of Ebola? How long does it take to pass a regulation? It could take months. So are you saying that in the case of something, utterly drastic, that we'd have to stop for months and have discussions and response periods and writing? The administrative code gives the Department of Health broad authority without there necessarily being a regulation in place. So how can you discuss the DPCL without discussing the administrative code?
Your Honor, I'm very pleased to discuss the administrative code. And there are two sections of the administrative code that have been referenced by the Secretary of Health. Section 4103, which is Title 71 of Pennsylvania Purds, and also Title 532, or I'm sorry, Section 532. Let me address 532 originally. In 532, it has the Department of Health shall have the power and its duty shall be, and it's important. The focus is on the we have the power. It's ignoring that we have a duty. The authority says, the first sentence, which is cited by the Secretary, to protect the health of the public, or protect the health of the people of this Commonwealth, and to determine and employ the most effective and practical means of the prevention and suppression of disease. If that means we can do whatever, we can put in place whatever we want to put in place without regard to the regulatory process, that violates the non-delegation doctrine, Your Honor. The case law is crystal clear. The legislature, the General Assembly, cannot delegate their sole function, creating law, to an administrative agency. If that language is read to mean that, that means that the legislature's basically said to the Secretary of Health, you set not only the public policy, you set the law. It's important that that section further, what's missing here in the Secretary's analysis, if you go down further to subparagraph G, and this is the duty aspect, Your Honor, and its duty shall be to promulgate its rules and regulations. That's the way the Commonwealth has established, the General Assembly has established, and I'll talk in greater detail about other control measures.
But the administrative code also says that it's up to the department to determine and employ the most efficient and practical means for the prevention and suppression of disease.
Correct.
It gives them the ability to act broadly but reasonably. It has to be efficient and practical. Absolutely. So what would you have everybody get a vaccination? What could be more practical based on what we hear from the CDC and the President of the United States as to the most practical way to curb this pandemic?
Well, with due respect to your Honor's question, that's a factual issue. That's the science behind this. This statute is written, may be completely inadequate to address a pandemic. That doesn't change the fact that it's the law. It's what we work with, and I'll explain why it isn't. I don't want to try to assert that it isn't. I'll explain why it is fully adequate. But the question relates to factual issues of whether wearing masks or that's not the issue. It's a purely a legal analysis here. So I agree with Your Honor that, and I'm going to touch on both administrative code sections, and then I'll get back into 2760 if it's all right with the court. I've dealt with 532. There's a duty to promulgate rules and regulations.
You're talking about the regulation.
Yes, I'm sorry. The administrative code. Then
But
there's
2760 is the regulation.
I'll get back into that regulation.
Okay,
Yeah, right now
all
I'm
right.
just trying to finish up, clean up
Yep,
the
yep.
administrative code sections. With respect to 1403, duty to protect the health of the people, very similar language. The paragraph A is almost verbatim to 532A. But you go on and look at the things that the administrative code cites under there. It talks about, examining nuisances, entering, examining, surveying all grounds, vehicles, apartments, and buildings and places. It goes on to talk about state health centers, reporting to the General Assembly, the general health and welfare of the Commonwealth of Pennsylvania. We cited the Alabama Realtors case, which is U.S. Supreme Court. We cited it, although it's a federal case, the analysis and the Supreme Court's conclusion with respect to that case and the ability of the Health and Human Services Agency at the federal level to mandate eviction moratoriums is analogous to what's right here. Yes, when they talk about in the administrative code the duties to protect the health of the people, what do they reference? They reference to talk about opening health clinics. They talk about going in and inspecting, surveying grounds, vehicles, apartments, buildings, and places to abate nuisances. It talks about reporting to the General Assembly. We're a far cry from that. We are mandating the wearing of face covers, the physical act of wearing face covers across the Commonwealth of Pennsylvania for anyone that enters a school.
But Counsel, you're not arguing that the department doesn't have the authority to do something like that. It's just that if they want to do something like that, they have to. They only have the power to do that through the promulgation of rules and regulations.
Correct.
And to my colleague Judge Seisler raised the issue of who really wants to wait around for that process. But if there is an emergency in place, that process is not something that takes place, I believe. And then there's also an avenue for expediting of the enactment as well. Is that correct?
There's emergency provisions in the Regulatory Review Act. And
also the Commonwealth Documents Law permits the waiver of the two publication requirement.
Correct. And the reality, Your Honors, is we're 20 months into this. It's been a rough 20 months for everybody in every profession and every walk of life.
But that's plenty of time to promulgate a regulation.
To say we haven't had enough time to get around to it, I quite honestly, I don't want to speak for Ms. Romano, but I don't think you're going to hear her say that today as a defense. We'll dive into 2760 if that's okay.
Very briefly, you're over your time. I'm going to try to keep everybody to their.
I appreciate that, and I'll walk through this very quickly. So 2760 provides isolation as a tool in the toolbox, surveillance, segregation, quarantine, modified quarantine. Neither of those are applicable. The Secretary is relying upon other health disease or other control measures that they deem appropriate. What they're missing and what they've left out is appropriate for the surveillance of the disease. And paragraph B answers how you determine that surveillance. What is the disease? What is the patient? What facilities are available and what other information is available? When you walk through, and this gets back to Judge Seisler's question about are there tools in the toolbox to address this? There's absolutely tools. And when they talk about other health measures, control measures, what they're talking about are all the regulations that follow. For example, there are specific regulations with respect to students. There are specific regulations with respect to those that work in schools, those that work in child care centers, those that work as food handlers, those that work at healthcare providers. All of those spell out different regulations, a myriad of different diseases that are listed there and how they need to be responded to, the treatment, the follow-up, how somebody's cleared to return to their job or other places. The Secretary of Health has the ability to access confidential medical records, to surveil, to understand. This is not surveillance.
Would your clients have any objections to regular testing?
Regular testing?
Yeah.
There are provisions in here for regular testing. So once again, as long as they're consistent with the regulations that are in place regarding regular testing, including the ability for forced treatment is in the regulations. The ability to restrict interstate travel or leaving an area of quarantine.
Aren't you sidestepping one issue, and that is whether or not this is a kind of order even contemplated by the statutes, whether it's the Administrative Code of 1929 or the Health Services, Disease Control Law, because aren't those statutes referring to discrete orders, except where they use the term rule or regulation? And here we have an order that has statewide effect.
Correct, and we believe it clearly meets the definition of the Regulatory Review Act of a regulation. We've contained that definition in our brief. It clearly meets that definition as a regulation, which requires it to go through the regulatory review process.
Counsel, very quickly, in subparagraph A, you noted that the provision about something that's all refers to what is appropriate for the surveillance of the disease. But the language you didn't mention, which is another caveat in there, is that the isolation, surveillance, segregation, quarantine, etc., apply to contacts of a person with a communicable disease or infection. Does having everyone wear a mask? I mean, have we even if it was there was a regulation in place, if you look at 2760A, there's no identification in an order, is there, with masks of people who are with communicable disease?
You're right, Your Honor. This is unprecedented that you would see a regulation put in place for healthy individuals. That whether you're vaccinated, unvaccinated, whether you think you've had COVID or you have had COVID, whether you think you've come into contact, whether you're exhibiting any signs, the mere fact that you enter a school building, which I do on a regular basis, enter a school building, you need to put a mask on or face cover. And then the definition, there is no definition of a face cover in any of the regulations, in any of the statutory provisions. The Secretary of the Department of Health had to come up with a definition of face cover, a definition of school entity, in order to put this order, i.e. regulation, in place. The definition of the face cover, it encourages people not to use N95s or other specially designed face covers, but to use things homemade, sewn together. It's that type of scrutiny that is the public has the ability to scrutinize, to get input through the regulatory review process. That's not done here. The public had no ability. Medical doctors had no opportunity to debate in a public forum. School administrators had no ability to debate the impact or the efficacy of such face cover orders. None of that occurred. This order came down out of the Secretary of Health's office with little or no forewarning. Quite honestly, the forewarning they received was going to be a determination made at a local basis.
Mr. Breath, may I interrupt for one question?
Yes.
And just to circle back, you went through what you consider to be certain powers that the Department of Health has right now, and including in that, you stated isolation and forced treatment, correct?
That's one of the powers, yes, under certain circumstances.
So you're conceding that the Department of Health could engage in that. Does the forced treatment include vaccination?
I haven't looked at that, Your Honor.
Okay.
I don't.
I mean, you didn't cite any of these provisions in your brief. I think we need to.
No, quite honestly, I was anticipating.
So I think we need to look at them before we ask you a question.
I was anticipating the question of if other health control measure isn't referencing what the Secretary has done, what is it referencing? And that's what it's referencing. It's referencing all of the various regulations that follow, in which you identify the disease, the patient, the facility, and any other information. That's one of the tools in the toolbox that the Secretary would have that has been approved through the regulatory review process.
Thank you.
Thank you, Your Honor.
Sorry, Mr. Breath, you're well over your time. So we're going to turn now to number 47. Let's hear from
Thank you, Your Honor. May it please the Court, my name is Jay Chadwick-Schnee from the Law Office of Tucker Hall here for petitioners in 47. Just want to kind of touch on the questions quickly. In terms of the vaccination issue, there is a provision within the Pennsylvania Code that states that for vaccinations, you have religious and philosophical objections to vaccinations that you can use in order to get out of the general vaccination requirements. I know this is about masks, not necessarily vaccinations, but there are provisions that recognize the Article 1, Section 3 right to practice religious beliefs, and also, similarly, the right of having a philosophical objection to vaccines here in
Are you
Pennsylvania.
talking about children, immunizations for children? You're not talking about adults, right?
That's correct, Your Honor.
Yeah,
It's the
just to be clear, right, okay.
Correct, Your Honor. Yeah,
Right.
it's for the part of the public school
For the
code,
school
school
process,
immunization
right.
requirements. Some of the questions that were asked in terms of the administrative code of Judge Sessler, I think the administrative code needs to be read in para materia with the Disease Prevention and Control Law of 1955. You know, the administrative code, as you correctly pointed out, Your Honor, is pretty broad in terms of what powers the department has. However, the Disease Prevention and Control Law is the one that actually sets forth what those powers are and sets the limits. There's really nothing within the administrative code at all that discuss face masking or what the specific powers are that respondent has in this case. So what I would argue is that those two statutes should be read together, and the powers that respondent has are quarantine, isolation, and other appropriate control measures necessary for the surveillance of a disease.
Of someone who's infected with the disease.
Correct, Your Honor. And actually, one of the arguments that respondent makes in their brief, in the 47 case, in the JW case, is that the order is actually a form of modified quarantine. But if you look at the definition of quarantine that's set forth in the Disease Prevention and Control Law of 1955, it talks about people being exposed to someone with a disease. I think it's actually section...
Is that Section 5?
I believe it's Section 5. So it states that under the definition of quarantine, a person must have been exposed to a communicable disease. So the order in this case, if it is a modified quarantine, or it is a form of modified quarantine, it really assumes that everyone is exposed to COVID-19.
Isn't that the case, though? I mean, it is rampant in the Commonwealth. It's rampant across the country. Over 700,000 people have died from the disease. 45 million have been tested positive.
What is that, 1.4% of the population?
That we've taken tests of.
Well, and I think the judge...
And it's an airborne disease, Mr. Snee. I mean...
Well, I guess the question is, can the secretary do whatever he or she wants, or do they have to follow the parameters that the General Assembly has set forth?
Right. I mean, as a creature of statute, of course, respondent only has the powers given to it by the General Assembly. In terms of Judge Wojcik, your point, with respect to what Judge Leavitt said earlier, is that you need a report of a disease. And as my colleagues, my fellow petitioners in the 47 case mentioned, or 46 case, that is limited to a specific occurrence. It's not a one-size-fits-all report of disease. It has to be limited in time, place, and manner. And in this particular case, you know, we can't just make the overall assumption that the one-size-fits-all blanket approach is the one that's going to work. You may very well have school districts in Pennsylvania, or school entities, which is broader than school districts, that there have been no reports of a communicable disease, of COVID-19, a daycare center in Wyoming County, or whatever the case may be. But the order purports to require all of them to require masking with no distinction or at all.
Could you run that by the panel again? So a report of disease, your position is it has to be discrete. And any other reading of the statute would give the secretary too much discretion?
Well, I think, Your Honor,
what does a report of disease mean? I mean, we're talking about all these other clauses. What do you think that means?
Well, I think if you read the 1955 Disease Prevention and Control Law, I mean, it's really, there's specific diseases included in there, like syphilis and other things, where there are isolated incidents of particular diseases. Of course, COVID-19 is a communicable disease. I'm not arguing otherwise. But there are specific reports of various diseases happening in situations as contemplated by the Disease Prevention and Control Law. In this case, there's really been no evidence or factual finding that in every school entity in the Commonwealth there is a current and active report of COVID-19.
So what would that take? Would a positive case in a school trigger the Department of Health's ability to issue a mask mandate for that particular school?
Well, in Allegheny County, for example, Your Honor, of course, Allegheny County has its own health department. So in my opinion, no, because under Section 3A of the Disease Prevention and Control Law, as well as the Local Health Authorities Act, that local county health department has the ultimate control. But I think, going to petitioner's point in this case, it's also not a control measure in the first place that is authorized by the existing statutes or by regulations. Masking is not being used for the surveillance of a disease. The term surveillance of a disease is set forth in the regulations. And what it means is the scrutiny or study of the disease. It doesn't mean a separate control measure. So masking is not a means of controlling a disease that is set forth in the statutes or in the regulations as they currently stand. And in terms of
advising the Secretary of Health, would you advise the adoption of a regulation that specified that a disease control measure should include face covering?
I would advise two things, Your Honor, in this case. I'll give them free legal advice. I would follow what the local health administrative law says in the Disease Prevention and Control Law in terms of Section 3C. Make a finding that the local disease prevention and control measure in a county with a health department is so inadequate that it constitutes a menace to the public health. Do what the local health administration law says and provide notice to county commissioners in any county in which a local county health department exists so that you can override the county's authority in that respect. And then in terms of promulgating a regulation, if this is a power that the respondent has by virtue of the Administrative Code of 1929 and the Disease Prevention and Control Law of 1955, then yes, they should try to promulgate a regulation, have it go through the Attorney General's office for legal review, as any other regulation would, to see if they have that power, and test it that way.
The power to
require masking, Your Honor. If they have the power to do it, they need to set forth a regulation to do so. As the statute says, they have the powers.
In other words, you think there needs to be a regulation that specifies that one of the disease control measures that can be chosen by the Department of Health is face covering.
Right. I mean, I think there's really two things.
And also list the circumstances.
Well, I think what you said was that first there has to be a determination under, 521(3), whether the local board or department has an unsatisfactory program.
That was point one.
And then,
okay. But could you answer my questions?
Yes, Your Honor, if I can remember what your question was. So in terms of masking, right. So going back to the regulation, so they could have had something in the regulation that said we can do any control measure, period. Right? It could have been a broad control measure. But what the regulation actually says is it has to be appropriate for the surveillance of disease. So they limited their own authority under their regulation. So if they want to expand the scope of that regulatory language, they certainly can do so, and they have the process to do so.
Okay.
I want to touch on the religious aspect as well. I know my time runs short. No, I think we've raised both a declaratory judgment action on the religious exemption to masking requirements, as well as an action under the Religious Freedom Protection Act. With respect to those two components, I think the important thing is that the order does not even allow for the consideration of religious beliefs. So in terms of whether it substantially impairs the practice of religious beliefs, and perhaps there may need to be some additional fact-finding on that, in which case this application for summary relief might not be the appropriate forum. But by not even allowing for the consideration of religious beliefs, it substantially impairs our petitioners' abilities to practice their religious beliefs. And so the question then becomes really, is it in furtherance of a compelling interest, and whether it is the least restrictive measure in furtherance of that compelling interest? You know, in terms of it being the least restrictive measure, you know, the order allows for individuals to be exempted from the mask requirements if they have a disability, or if under Section 3 of the order, if wearing a mask could cause or exacerbate a mental health, physical condition, or a disability. Cause. You know, that implies a future event, not a current event. So there are broad exemptions that are already in the order for medical reasons. So it would be the least restrictive measure in this case to also allow for at least the consideration of religious objections to masking requirements.
So your argument is not based on the identification of a particular impairment or imposition on the free exercise of religion. You're just saying there has to be an opportunity to make that case, and there is no opportunity.
I think we make both arguments, Your Honor. I think argument one is yes, there needs to be at least an ability to, there must be a process. Due process has been the theme of the day for this court. You know, there has to be notice and an opportunity to respond. There has to be a forum to have these people heard out. In particular, with our respective petitioners in this case, we believe that their particular circumstances justify their own substantial impairments. But, you know, if there is a process set forth in the order, you know, or if there's a process set forth by this court, if the order still stands, that may help alleviate that, in which case the ultimate decision maker might be a school district in that case.
Mr. Sneed, can you articulate for me how an individual's religious liberties are impaired by the mask mandate?
Sure. I mean, I think we set forth in our complaint, you know, our particular plaintiffs and their beliefs. One of our plaintiffs believes in faith healing, and that this impacts her ability to practice that belief, that we don't need medical devices for that purpose. One of my other plaintiffs has strong religious beliefs that she alleges that it is akin to participating in a satanic ritual. That is their personal beliefs, you know, and certainly, you know, if we need to amend the complaint or have additional fact-finding in terms of specific scriptural passages to address those issues, certainly happy to do so. And as I said, this might not be the appropriate forum for a summary relief if we're dealing with those particular issues. But as part of that, I would note that under Section 1419 of the Public School Code, what it states is that if you have a religious objection to a medical treatment, you're allowed to opt out of whatever that medical treatment is, and the school cannot discriminate against you on the basis of that religious objection. You know, in this case, the order, what respondent is asking is they're not asking county health departments to do anything. They're asking school districts to do things. So what they're asking is school districts under the authority of the Public School Code to enforce and implement this order. And so because it's being administered under the public school law, I think every person needs to be allowed to have an ability to object under Section 1419 of the Public School Code. And then just in terms of due process, Your Honor, you know, our allegations in this case are that, you know, there are some fundamental rights implicated here. There's the right to breathe clean air. I mean, wearing a mask for 6 hours or more certainly impacts that clean air ability. There's a fundamental right to receive a public education. There's a fundamental right to deal with the care, custody, and control of your children. And there's other constitutional rights involved, too, in terms of Article 1, Section 3. Those are all set forth in our brief and our petition in this case. When there's a fundamental right at issue, due process is triggered. And in order for due process to work, there has to be notice and an opportunity to respond. One way of that happening is through the regulatory review process. That gives everyone notice of what the particular issue is, gives people an opportunity to comment and weigh in on what that regulation is. But as respondent admits here, there was no notice or an opportunity to respond. In fact, you had many schools that were already in session prior to this order being issued. So because there's a fundamental right and there was no notice or an opportunity to respond, we believe this court should strike down the order in its entirety because of that lack of procedural due process.
I believe you also allege that many of the school districts already had plans in place and had made certain representations to the parents and the students in the community. And there was no contact with them telling them prior to this order that their plans were unacceptable. And right.
Correct, Your Honor. Yeah, under the American Rescue Plan, in order to receive federal funding, every school district in the Commonwealth had to submit a health and safety plan as a condition of receiving federal funding. Every school, well, not every school, many schools did so and received those federal dollars as a result. Importantly, under the American Rescue Plan, while it says a school district has to address what they're doing with respect to masking, it doesn't say they had to require masks. And if you look at the testimony from the Senate Education Committee hearings with the Secretary of Education during his confirmation and also afterwards, he specifically said that no American Rescue funds would be withheld from any school that chose to not follow the CDC guidance and to make masking optional. So in terms of a democracy and weighing of interests and having a debate about the efficacy of masks and whether it's appropriate or not, many school districts, I think all school districts, did so prior to this August 31st order. Many schools chose to make masks required. Many schools chose not to. And unfortunately, respondent came in here with no notice or an opportunity to respond and supplanted the authority of all of these school districts. Thank you.
Thank you. All right, we will hear from the Secretary of Health.
Good afternoon. May it please the Court, I am Chief Deputy Attorney General Karen Romano, here on behalf of Acting Secretary of Health Alison Beam.
Counselor, are you aware of any other state that has this sweeping mandate for schools where it's been upheld?
Your Honor, I'm not aware of another state with the same mandate, but I'm also not aware of another state with the exact same statutory structure that we have here in Pennsylvania. And that's what we need to look at. And if you look at the complete statutory framework here, there is clear authority for the Secretary to issue an order like this. The Administrative Code of 1929 mandates that it is the duty of the Department of Health to protect the health of the people of the Commonwealth and to determine and employ the most efficient and practical means for the prevention and suppression of disease.
Now, that sounds like you're telling us that you think there's unlimited authority and discretion.
There's not unlimited authority and discretion, Your Honor, but there is broad discretion, and rightfully so. When the legislature enacted the Administrative Code, the Disease Prevention and Control Law, they couldn't have envisioned every communicable disease that would have ever...
They could have envisioned swine flu and tuberculosis.
They could envision... Certainly, Your Honor, there were diseases that existed at the time. COVID was a new novel virus that no one could have anticipated. We could still have more novel viruses coming in that we can't anticipate and don't know.
The concept is a communicable disease, and that concept has existed before. But when you look at the code and you cite A, can we ignore B through N, which I think counsel for the petitioners already noted, and they all have to do with nuisances, examination of nuisances, abatement, removal, promulgating rules and regulations, conditions exist in any borough, they can address the menace, take over administration and health laws in borough or township whenever they shall request. That request wasn't made here. To prescribe standard requirements for medical inspection, to investigate and hold hearings, to train, to make available appropriate facilities, to make bacteriological examinations, and that's it. There's nothing in there about any particular other rights, but those are addressed in other provisions of the regulations and statutes in the Disease Control and Prevention Act.
Your Honor, we go back to the Administrative Code makes it the duty of the department to protect the people and to employ the most efficient and practical means for the suppression of disease.
Yes, but if the General Assembly has set out the means by which they do that, which is to first to say local boards and departments have autonomy, and they can't go in there except when they determine that the plans that are implemented are not appropriate or when asked. How do you get around that?
That's not exactly what it says, Your Honor. I'll respectfully disagree on that point. Not every county has a local Department of Health. I think there's 6 that have a local Department of Health. There are some other local boards of health. All of those entities operate under the supervision and guidance of the Pennsylvania Secretary of Health.
Well, that's true, but they're not sub-departments of the Department of Health. You know, the Secretary of the Commonwealth provides guidance to county boards of election, but the county boards of elections are not sub-parts of the Department of Health, and neither are local county health departments. They stand alone, and they have their own organizing statute, as does the Secretary.
But, Your Honor, if you look at section 521.16 of the Disease Prevention and Control Law, it specifically states that those municipalities that have those departments or Board of Health, they may enact ordinances or issue rules and regulations relating to disease prevention and control, which are not less strict than the provisions issued by the Department of Health.
That goes to preemption.
Right.
And that's not what we're dealing with here. We're talking about a statutory scheme that gives primary responsibility to the local boards of health. It has nothing to do with the enactment of ordinances. There's no question they can enact an ordinance that is more relaxed in how disease will be. In other words, they can't promulgate or adopt an ordinance that conflicts with the Department of Health regulation, for example.
Your Honor, we have to look at what the magnitude of the communicable disease is. The local boards and departments are mainly designed to deal with local outbreaks. There's a measles outbreak in a local school or a local hospital, and the local department needs to step in and implement measures to control it.
That's all well and good,
That's
but
a good explanation, but where does the statute say that?
Well, Your Honor, certainly the Allegheny County Department of Health doesn't have the authority to implement a disease control measure in Lycoming County. They're designed to deal with local issues.
But you raise
Absolutely.
a good point. Allegheny County has a Department of Health. It's a very large county. That's where I live. Just because there are counties without local departments of health doesn't allow the secretary to jump over 521.3C for all of the counties that do.
Your Honor, it's our
Just
position
to that
that
point.
when there is a communicable disease that is Commonwealth-wide, the secretary is the one that is tasked with protecting the individuals in this Commonwealth. She is the one who is tasked with determining what is the most appropriate disease control measure to prevent further spread. And that's what she's done here.
And
that's
not
specifically
subject
authorized.
to any other laws or regulations.
Subject to the administrative code, the disease prevention and control law, and the department's own regulations.
So
yes.
this brings up a very good distinction. So you read to us a section which talks about the Secretary of Health having the duty to protect the health of the individuals of the Commonwealth. But you're not relying on that section to say that you have limitless authority and discretion to do that ad infinitum, although arguably the order that's in place doesn't have any endpoint. You're saying that the order that's in place comes about, and your authority to do it comes about not because of simply a duty to protect, which is just a general duty, but because of a rule or regulation that's already in place. So you agree with the argument that unless there is a rule or regulation in place, you did not have the authority to do this. You think there is a rule or regulation in place, correct?
We believe there is a rule or regulation in place, yes, Your Honor. We would point
Tell us about those.
Okay, certainly. So if you look at 27.60 in the rules of regulations, they give the department the authority to isolate a person with a communicable disease. Certainly that hasn't been done here. Secretary has the ability to engage in surveillance, segregation, quarantine, or modified quarantine of any context of a person with a communicable disease, or any other disease control measure that the department determines is appropriate for the surveillance of disease when that measure is necessary to protect the public. You have to look at the definitions to get to the full scope of this, of surveillance of disease and of modified quarantine.
And tell us what surveillance of disease means.
Give me 1 second to turn to that, Your Honor. Surveillance of disease is defined, this is 27.1 of the PA Code, Section 28 PA Code 27.1. It's the continuing scrutiny of all aspects of occurrence and spread of disease that are pertinent to effective control. And what petitioners do are taking select portions of these statutes or these regulations
Well,
out
the
of
word
context.
scrutiny is what he mentioned before. Scrutiny or study.
Correct, Your Honor. But if you go to the end of that where it says pertinent to effective control, you can't take the word surveillance or scrutiny out of context and say all the Secretary has the authority to do is sit back and watch this virus. And watch
No,
how it's
I think
spreading.
they're saying that you can survey, and you can quarantine, segregate, isolate persons with a communicable disease for the purpose of what is appropriate for the surveillance of the disease. That's what A says. That's what their position was.
And I'm looking at 35 PS 521.2 definitions under the chapter for prevention and spread of diseases. That indicates that surveillance is the close supervision of persons and animals exposed to a communicable disease without restricting their movement. So how is it that this particular order relates to a disease control measure for the surveillance of disease?
So first, let's look at the definition of modified quarantine. So it's a selected or partial limitation on the freedom of movement determined on the basis of the danger to the person. You know, I was at a hearing here, an argument here about 2 weeks ago virtually before Judge Wojcik, and he opened the hearing by saying, we were here in a prior hearing in this case and masks have been optional. And that had turned out to be a mistake because someone in the courtroom was positive with COVID-19. That's the problem we have. We don't know who is positive.
Counsel, we have all learned about the dread aspects to this disease. And I would ask that you, and this is the same argument I would make to all counsel, let's focus on the legal question. And you had a question from Judge Fasano-Cannon directly to your argument under the regulation, and then you switch to modified quarantine. How does that respond to her
So that is part of my answer, Your Honor.
The question was close supervision of persons and animals exposed to a communicable disease without restricting their movement. Does a mask restrict movement?
It does restrict some freedom of movement. It also works as a building restriction or a facility restriction. The Secretary has the authority to issue a restriction in a building that they can remove students from the classroom, per se. That's specifically under the modified quarantine section. This is a less restrictive means. This isn't a means that's just willy-nilly selected either. It's recommended by the CDC. It's recommended by the American Academy of Pediatrics.
Well, we're not here to talk about the efficacy of the mask. The counsel said that specifically. That's not what the case is about today. The case is whether the Secretary had that authority. And you pointed to 26.60 under the PA Code disease control measures. And then I'm looking at 521.5 and 35 pardons, control measures. And it says, upon the receipt by a local board or department, again, referencing back to the local autonomy of those entities under 521.3, or the department, as the case may be, of a report of a disease which is subject to isolation, quarantine, or any other control measure, they identify shall carry out the appropriate control measures as is provided by rule or regulation.
So, Your Honor, because we can't specifically say who has COVID, and we know that it can be, you can be asymptomatic and be positive with COVID, you essentially have to treat everybody as a contact of that potential person. And the person who's positive in that school building or in this courtroom is effectively the patient. So requiring the masks by all of the potential contacts is a modified quarantine placed on those individuals.
Okay, but you still have to have a rule or regulation.
Right, so isn't what you're doing actually changing the language of the existing rules and regulations, which you can't do and that you would have had to do by going through the process?
No, Your Honor. The modified quarantine is specifically listed in there, and if you look at the...
What is the definition of modified quarantine? Doesn't it make reference to persons or animals who have been exposed to communicable disease?
And certainly, Your Honor, and anyone that's in a building with someone who's positive with COVID is exposed to that communicable disease, and that's why the measure is necessary.
But I don't believe that the mask mandate takes into consideration whether or not an individual has been exposed to the communicable disease. You're making the assumption that everyone has been or is.
Your Honor, with a communicable disease like COVID that has killed the number of people that have been killed, we have to take that assumption. That everyone in that building, a building is largely made up of people unvaccinated.
You still need a rule or a regulation.
And Your Honor, 27.6 gives them that authority. And if you look at the...
No, 27.6 gives you the authority... Yes, 60 gives you authority to surveillance people or quarantine someone with a communicable disease. Nowhere in there does it say you can restrict the movement of or infringe upon everybody. You have to.
But it says,
you have to be a person with, not someone exposed with a communicable disease.
But it says that the department can implement disease control measures. And if you look at the preamble when they promulgated the regulations.
I'm sorry, counsel, I just want a clarification. You referenced 27.6 or
60, Your Honor.
60. All right. Okay.
If you look at the preamble when they promulgated the regulations, they specifically noted this would allow the department the discretion to implement the most appropriate disease control measures for the situation. That's what they're doing. That's what the regulations allow. The legislature recognized that the Department of Health, with their team of medical professionals and epidemiologists, are the most informed group to determine what is an appropriate disease control measure.
You still need a rule or a regulation.
Yeah,
look at 521.5. That's the language that you're reading about, or isolations, quarantine. You have to have a rule or a regulation. So, in all this time, I'm sorry, go ahead, Judge Sanikin.
You go ahead, I don't want to interrupt you.
In all this time, I think counsel pointed out, it's been 20 months. No rule, no regulation.
Your Honor, it's our position that the existing regulations where they allow for surveillance, segregation, quarantine, or modified quarantine of contacts of a person is sufficient, along with being able to surveil the disease to implement effective control measures, which is what the law requires of the Secretary.
So the section that you make reference to on the disease of control measures, though, only discusses those that are going to be isolated, surveilled, segregated, quarantined, or modified quarantined, or other control measures that are appropriate for the surveillance of disease. The next section after that goes on to describe what measures will be determined appropriate based on the disease or the infection, the patient's circumstances, again emphasizing individuals who have been exposed, the type of facility available, again emphasizing the fact that we're talking about people who will be contained to be surveilled or to be quarantined. So it doesn't quite fit. And I understand that circumstances of today aren't necessarily those that were contemplated at the time that this regulation was put in place, and that things have come about that are different, but we still have a process. So it's hard to understand why it is that that process wasn't followed in this case. In this particular case, Governor Wolf had come out, he had said that he was not going to issue a mandate with regarding masks, and then just before school started, that mandate came out of your office. Why not consider another emergency order? Why not consider an expedited path to enacting or promulgating? Why didn't any of that happen? And what accounts for the limitlessness of the particular order, what seems to be very broad discretion and the unlimited time?
Your Honor, what changed was the facts on the ground. And that's what we've been dealing with for 20 months now, is the facts on the ground are changing. If you look at the order itself, it cites the numbers. In those first 2 or 3 weeks that children started school, the numbers skyrocketed. The Delta virus was rampant. This group of children, largely under 12, can't be vaccinated, and the numbers were skyrocketing.
But it seems from the beginning of your order that what you're actually saying is that you are feeling the threat and that you feel that there's an emergency, another emergency. So why an order in the sense, and not going the way of what ultimately was scrutinized in the cracked egg case when there was an emergency order in place?
Your Honor, the Secretary has, as the court recognized in cracked egg, the Secretary has independent authority, aside from the governor and aside from an emergency declaration. And that's how this order was entered. This was a measure by the Secretary to prevent the spread of disease throughout the Commonwealth. And an emergency declaration wasn't necessary under her independent authority that's granted to her by the legislature.
But where does that authority, I understand that you believe that that authority is contained in the regulations, but what is the limit of that authority? I mean, this order in particular, I believe, states that it's in existence until you decide that it's not, or the Secretary.
So, Your Honor, she's limited in the fact that, one, there has to be a report of a disease, which we have a report of COVID-19 in every county in this Commonwealth. She's also limited in the fact that she can only implement disease control measures that are appropriate for that disease. She couldn't come out right now and say everyone has to wear a hat. That's not related to the control of that disease. The wearing of masks has been proven by the science to prevent the spread of the virus. It is our least restrictive.
There's conflicting science on that, so let's not get into the efficacy of wearing a mask. We're not here to determine that. We're here to determine whether the Secretary had authority. We've already talked about the regulations and all the very clear limitations, and I appreciate your arduous effort to dissuade us of that, or at least me. But the primary thing I think that you hung your hat on is the general statement to protect the health of the people. And when you look at the rest of that provision in both sections, it talks about nuisances and all other different things. So can you explain why interpreting that Provision A as so broad to entitle the Secretary to make any kind of determination that he or she decides is not an unauthorized delegation of authority?
Certainly, Your Honor. So there are, here's a situation where the legislature did determine the public policy. They determined that the policies that the Department of Health is better situated to make these determinations, and they set parameters. You have to have a report of a disease. You can only implement measures that are reasonable to the control of the spread of the disease. But the Secretary has to have broad discretion when the legislature couldn't have known everything that would befall us in the future.
Well, could I ask a question? Because the latest round of questions is really focusing on what are the limits of the Secretary's discretion. There's no limit as to time for this order. Now, what if the order is still in effect in 1 year after there is a vaccine available to children? What if there are treatment measures so that there are almost no reported cases of COVID-19? What's your remedy if the Secretary chooses not to rescind the order?
Your Honor, I think that'd be a very different set of circumstances.
Well, maybe, but there's no limit, is there, as to time?
Well, Your Honor, I think at that point in time, these measures may not be reasonable anymore to preventing the spread when you have a vaccine widely available.
Okay, and how do you challenge it then?
The same way we are now, Your Honor.
No, we're challenging it on the grounds that this is a binding norm. This is a regulation. What is this order? If it's not a regulation, is it just a...
It's a disease control measure, Your Honor. It is an order implementing a disease control measure.
And how do you challenge that order if it's unreasonable? If it does make you wear your hat when you're in school?
Your Honor, I think that someone who thought it was unreasonable can challenge it the same way that petitioners have been challenging these orders for 1.5 years now. I've been in countless courtrooms with petitioners challenging these orders for 20 months.
Isn't there an administrative mechanism through the GRAP that allows an informal complaint to go to the Secretary?
Your Honor, certainly I think that may be a course, and certainly if there was a regulation implemented, I think that would be the course, but that may be a remedy that's also available.
And is that a remedy that could have been used by the petitioners here?
Potentially, but we're certainly not arguing that they're improper coming before this court.
Okay.
Well, that still not... Tell the court why this is not a regulation.
So,
it has, does it not, all the indicia of a regulation? It's statewide, it affects all schools, it affects all children. Isn't that the hallmark of a quasi-legislative order or action as opposed to an adjudicatory act?
Your Honor, one point I would note on that is the case law that is cited by the petitioners, one of the provisions they cite is the fact that with the rule or regulation, the agency's discretion is restricted by the provision. The Department of Health has not restricted their discretion in any way by implementing this order.
You haven't answered my question. Why isn't this a regulation according to the traditional understanding that it's a binding norm, binding on the agency as well as the public, namely every school and every school child? Why is that not a regulation?
Your Honor, and that's what I was going to. The case law they cite to that talks about what creates a binding norm. One of the factors they look at is, does it take away the discretion of the department? And this doesn't. This leaves the discretion intact for the department to determine what is the most appropriate control measure to combat a disease.
Well, no, I think what the argument is that you're not following your own regulation, namely 2760.
Your Honor, the department would disagree with that.
But that's in that respect, because you are allowed to, as been pointed out, pursue any disease control measure appropriate for the surveillance. That's your limit. You're limited to the appropriate control measure only for surveillance.
But Your Honor,
and you're not, you're engaging in. I understand your argument, but you're saying it's not a. I want to just get to the basics. It's not a regulation because it's not binding on the department.
Your Honor,
your order doesn't ask the department to do anything, and therefore it's not a regulation?
Your Honor, we didn't. It is our position that no regulation was necessary because this is authorized specifically by the regulations.
I'm trying to by traditional, standards that have been in effect for close to 100 years. We understand what a regulation is and what the government must do when it promulgates a regulation. By those traditional standards, this is a regulation. It affects every school and every child, does it not?
Limited to certain exceptions, yes, Your Honor. I mean, there are exceptions within the order, but generally, yes.
Right, but so in that respect, you have to concede that it is a regulation. It meets all of the criteria of what is a regulation.
Respectfully, Your Honor, the Secretary would disagree with that characterization as we've set forth in our papers. I know my time is up. If I could briefly just touch on the religious aspects here that are raised in the JW case.
Sure.
And the due process. Thank you, Your Honor. It is our position that this order is of neutral, general applicability. It does not in any way impact anyone's ability to practice their religion or exercise their religion. Counsel argued perhaps more facts would be needed on that point, but they've agreed that there aren't facts at issue. They asked for one factual stipulation and otherwise said this was a legal issue. There's nothing pled in their petition that asserts any infringement upon the religious beliefs.
Let me ask you this, please. Is your concept of ordering people, the Secretary's concept, of ordering people to wear a mask for medical treatment, is it a medical treatment? It's a prevention of a disease, according to that office?
Your Honor, it is not medical treatment.
Okay, well, I guess that's the factual issue. Because if it is, 24 Purdon's 1419 makes clear they can't be forced to do it.
Yeah, we do.
They have a right to assert a religious ground on that basis anyway.
Right, Your Honor, and there's nothing about wearing a mask that treats COVID-19. It is a disease control measure that prevents the spread of respiratory droplets.
But your job is, the Secretary's job is to protect the health. If this isn't a medical treatment, what is it?
It's a disease control measure, Your Honor.
Yeah, it's protect the health. Okay.
To protect the health, to prevent the spread of those respiratory droplets.
And so is a vaccination, allegedly. Is that not medical treatment?
I would agree with you that vaccination is medical treatment,
Oh, you're
Your
going to
Honor.
draw the line between one treatment and another. Okay, I understand.
I believe the petitioners in number 47 are taking the position that, and you still have rebuttal time, by the way, but I believe their position is not that there is absolutely an interference with the exercise of religion, but there's no opportunity to get an exception. Could you address that?
Certainly, Your Honor. It's essentially they're making a facial challenge, but there are all sorts of laws of general applicability without a religious exemption. There's no religious exemption to wearing a seatbelt. There's no religious exemption to speeding. Even if you look at the laws of the Affordable Care Act, that law wasn't invalid because there wasn't the opportunity for a religious exemption facially. Later in Hobby Lobby, they looked at an as-applied challenge, and made a determination there. But facially, the statute doesn't fail because there's no exemption.
That argument only applies if you can successfully argue it's not treatment.
Well, Judge Leavitt was correct. Yeah. And we don't believe it is treatment. Touching quickly on the due process, we don't believe that that the petitioners have been deprived of any rights here that would implicate due process. They're arguing they're deprived of public education. Our schools are open. Our schools are educating students every day. They're not being deprived of that education. They're not being deprived of the ability to breathe clean air. Certainly, schools can implement mask breaks and different policies to give children a break from wearing masks throughout the day. And as we've stated, it doesn't implicate their ability to practice their religion.
Are they prohibited from attending school if they don't wear the mask?
In person?
Yes.
Yes, Your Honor.
Well, there's no guarantee they're going to get an online. I mean, you don't know what the different school districts are going to do, so they are being denied the opportunity to go into the public school or any school for education.
Your Honor, it's essentially a building restriction, no different than you're denied access to this building if you won't go through security.
I'm not getting I do get an education here, but it's different than right to a public education.
Well, Your Honor, I mean, it is our position that they certainly have the right to be educated. It's no different than requiring, students have to wear pants versus shorts, or dress code restrictions, or other sorts of requirements on students. It's one more just rule that's in place for them to attend in person, and that's why it's designed, is to preserve in person.
If it's not a treatment.
It's not a treatment, Your Honor.
If it's not a treatment.
Correct.
Yeah. Okay.
Thank you.
Thank you very much. All right. We will now, the court is going to get stricter on the 5-minute limit.
Judge Leavitt, I'll try not to take anywhere near the 5. Just a couple points, Your Honor, judges. Let me start with, we're here on applications for summary relief. The petitioners, this is a legal argument. The Secretary of Health wants to talk about a bunch of stuff that isn't in the record, a bunch of factual stuff. For that purpose alone, their application for relief should be denied. Secondly, with respect to the issue of, let me make sure I just get my thoughts straight here. For the first time today, we're hearing the Secretary blend the interpretation of 2760. If you reference the Secretary's order, she specifically refers to, and I'm on page 3 at the top, when she's citing the authority. She used the terminology, may order general control measures. She goes on to talk about any disease control measure. For the first time, we're now hearing that it's not only the other appropriate control measures for the surveillance of the disease. We're now hearing that, no, this is maybe a modified quarantine under the previous language in that section. That argument has never been put forth in the briefing schedule, to my knowledge and recollection. It is not, it wasn't asserted in the order. It's an effort to avoid, we would respectfully assert, the for the surveillance of the disease language that creates a problem for the Secretary, because this has nothing to do with surveilling the disease. This is a physical act of wearing a face cover.
So you're saying the order itself does not articulate the theory that this is a modified quarantine?
It's the first time we've heard that, to my knowledge, in written format. Certainly the first time that it's been argued before this court, in our opinion. Thirdly, and with this I'll conclude, with respect to the limits, what are the limits? We've been talking about COVID-19 because that's the matter that's before the court. The legal theory that the Secretary is asserting isn't solely applicable to COVID-19. It's applicable, if this court finds that the Secretary has this authority, to all communicable diseases, including the ones that are listed throughout the regulations. This is what the United States Supreme Court said, per curiam opinion, in the Alabama Realtors case with respect to the Department of Health and Human Services moratorium on evictions. Indeed, the government read of Section 361A will give the CDC a breathtaking amount of authority. It is hard to see what measures this interpretation would place outside the CDC's reach. And the government has identified no limit in Section 361A beyond the requirement that the CDC deem a measure necessary. That is the exact same argument that the Secretary of Health is making here today. It's necessary, so I have the authority to do it. We would respectfully assert that when passing the Disease Prevention and Control Act, the General Assembly made it very clear, you have the authority to impose disease control measures in a manner and in a place consistent with existing rules and regulations. I added the word existing, sorry. In accordance with rules and regulations. That is the limitation of the Secretary's authority. There is no rule or regulation authorizing the mandating of face covers within the Commonwealth of Pennsylvania in school districts or otherwise. We would ask you to affirm or grant petitioner's application for summary relief in this matter. Thank you for your time and your patience.
Thank you.
Thank you.
Your Honor, I'll be brief. The word quarantine, my understanding from doing a quick word search last night, is not in the order itself. So to the extent the argument is that this is a modified quarantine, I don't believe that word quarantine even appears in the order. Judge Wojcik asked a question about GRAP, the General Rules of Administrative Practice and Procedure. That actually is the way you put forth due process. The GRAP requires and puts forth regulations out there for administrative procedures that allow parties to have due process. I don't think GRAP necessarily applies here because you've had an order that's issued completely outside of any kind of rulemaking or adjudicatory process.
Would apply to a quasi-adjudicatory action. That's quasi-adjudicatory?
Your Honor, I think your question is the million-dollar question. What is the order? Is it a regulation? Is it a statute? Is it something else? From my understanding, it sounds like it's something else. It's I guess, an order allegedly issued pursuant to regulatory authority on the books. So I'm not sure if it's really adjudicatory in nature. I will say
generally an adjudication is limited to just a discrete small number of people. This is every school child in the Commonwealth of Pennsylvania.
Correct. Normally you have parties. Normally you have a hearing. Normally you have notice of that hearing. Normally you have a hearing officer that oversees it. None of that happened here. In terms of the limits of the Secretary's authority, there really are none under their interpretation. The Secretary could shut down all schools today in order to stop diseases in schools. That's the limit. I mean, there is none. You know, that's the authority that respondent would have you believe they possess here. You know, in terms of a report of disease as well, I mean, I think the other kind of more nuanced question is, does it have to be an active report of a disease, or can it be an old report of a disease? So a lot of the numbers that are cited in respondent's brief are cumulative numbers of COVID cases throughout the state and counties and that sort of thing. But the real question is, what's the active number? What are the continuing numbers and increases for that purpose? If there are no continuing reports, new reports of disease within particular school districts or school entities or areas served by school entities, there's no reports of a disease. It can't just be unlimited, we once had a report of a disease a long time ago and therefore we have the authority forever to do something. In terms of the dress code issue I think is pretty clearly not something that the Secretary of Health has as a power of authority. School boards certainly do. The Secretary of Health does not have that authority. I think the important thing is, in terms of the regulatory review process, is that, you know, as Judge McClure pointed out, there have been other respiratory pandemics and epidemics in the past, including the H1N1 swine flu in 2009. It's to do the math correctly, about 12 years since that occurred. That's certainly ample enough time to promulgate a regulation. Certainly COVID's been around since the beginning of last year, also a sufficient amount of time. You even had that emergency declaration in place where potentially you could have gotten expedited review of regulations during the COVID-19 disaster declaration when it was in effect, and respondent chose not to do that. The people that did choose to weigh whether masks were appropriate were school districts. And school districts all made their choices, and respondent didn't like their choices. Thank you.
Thank you. Okay.
Your Honors, unless the court has further questions, we'll rest on our brief and waive our rebuttal time. Thank you.
Thank you.
We got you all the questions.